Editor-in-Chief, yeah. Hi, good morning, everyone. Welcome to the Case Western Reserve Law Review Symposium, and thank you for joining us. And welcome to our speakers. Thank you for coming from... Speak louder? Sorry. Thank you for our panelists for joining us. Before we get started, I just wanted to say a quick few thank yous, and then I'll introduce Professor Katz, who will be giving our introduction. First, I'd like to thank our panelists for joining us. Both Steve and I are really excited about the topic and to have you all here, and I think it's really going to be a great day. I'd also like to thank Alice, Simon, and Nancy Pratt for all their help organizing the symposium and getting everything ready to go, so thank you to them. And Professor Enton, our advisor, who was so much help throughout this whole process, and he'll be joining us in a little bit this morning and moderating one of our panels. And lastly, I'd like to thank the Law Review staff who, for all their hard work, and especially Steve Day, who many of our panelists worked with to get here, and he was the real driving force behind today, and he was a great help. And now I'd like to introduce Professor Katz, who will give a brief introduction today to the symposium. Professor Katz is the John L. Hutchins Professor and the Director of the Master of Laws in U.S. and Global Legal Studies program. He teaches both criminal law and criminal procedure and has written numerous articles and books on both topics. He's been a professor here at Case since 1966 and actually taught my very first law school class. So thank you for joining us, and without further ado, Professor Katz.
Good morning. To put this in perspective, I started teaching here at then Western Reserve University Law School the year before Brady was decided. An argument often made over the last half century against the Fourth Amendment exclusionary rule is that ordinary citizens lose faith in the criminal justice system when guilty defendants go free. That may be the case. However, ordinary citizens and lawyers and judges alike should be truly alarmed when they see the criminal justice system unable to distinguish between innocent and guilty defendants. The credibility of the criminal justice system is completely dependent upon its ability to ensure that innocent people are not convicted. It's too late in the day to believe that innocent defendants are not convicted of crimes in America. Nor can we avoid the fact that innocent defendants have been convicted not just as a result of innocent errors. The release of defendants exonerated after years in prison is evidence of a system that eventually works, but at the same time, it is also evidence of a system that is subject to terrible error, resulting in costly human tragedy. It raises ongoing questions about those who may languish in prison, wrongfully convicted, and never exonerated. It is fashionable to joke about how all prisoners are innocent, just ask them. But tragically, some are. The rules governing prosecutors are few and direct. A prosecutor may not deliberately misrepresent the truth, as in Miller versus Pate, where the prosecutor misrepresented a pair of shorts found about a mile away from a murder scene as blood-stained, even though the prosecutor knew the stains were paint, not blood. The state used a chemist from the State Bureau of Crime Identification who testified that the stains were blood, knowing that they were not blood. The Supreme Court said the 14th Amendment cannot tolerate a state criminal conviction obtained by the knowing use of false evidence. 40 years later, issues concerning the integrity of some crime labs persist. The Due Process Clause also requires the prosecutor to correct perjured testimony. Moreover, the prosecutor's duty does not stop with direct facts about the crime itself, but extends to perjured testimony that goes to matters of credibility. These rules are intended to promote the reliability of the guilt-determining process by reducing the possibilities for wrongful convictions. It's an outrage that violations of these most basic duties continue to occur today because they are such basic tripwires intended to prevent miscarriages of justice. A prosecutor may not knowingly use perjured testimony. Perjury creates the same duty whether it goes to an essential fact of the case or to a collateral matter. The prosecutor must correct a witness's false statement that he had not received a promise of leniency in return for his testimony. Moreover, the prosecuting attorney's ignorance is no excuse. The prosecuting attorney trying a case has a duty to find out whether promises have been made to her witnesses. Any other rule would encourage willful blindness on the part of the attorney trying the case. Yet anyone who was around the Cuyahoga County Courthouse for the last 30 years of the 20th century knows that accomplices and jailhouse snitches routinely denied that any promises had been made, and prosecuting attorneys equally routinely let those denials stand without correction. The continued importance of jailhouse snitch testimony and incidences of jailhouse snitch perjury indicate that we have not come very far in our pursuit of ensuring that juries be made aware of the currency of exchange for testimony. We certainly have not eradicated the perjury issue, but the United States Supreme Court recognized that the prosecutor's duty to see that justice is done involved more than just correcting perjury. In Brady, the court said, "We now hold that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of good faith or bad faith of the prosecution when the defense attorney makes a specific request." Brady was as important for the type of evidence involved as it was for the holding. The evidence was not a bombshell which would have exonerated the defendant Brady. At Brady's trial, he admitted to participation in the felony. In fact, his attorney conceded his guilt on the felony murder. The defendant had made a specific request for the statements of his co-defendant, and the prosecutor released two of his statements, but failed to release the third statement in which the co-defendant admitted shooting the victim. But in that third statement, Brady was incriminated. The accomplice indicated that Brady wanted to strangle the victim rather than shoot the victim. That clearly would have been useful in the punishment phase, indicating that Brady had not actually killed the victim. But it wouldn't have gotten Brady off the hook. The jury might still have sentenced Brady to death in that particular case. So the important thing about Brady was it wasn't going to exonerate him, but it might have been helpful to the defense in making the argument for life in that particular case. Brady seemed to herald a new day in recognition of a prosecutor's higher duty to see justice done. It is the prosecutor who knows or should know, despite heavy caseloads and insufficient preparation time, where the weak spots and inconsistencies are in case files. The prosecutor or the police knows when witnesses have come forward with information which does not match the suspect that became the defendant. It's the prosecutor or the prosecutor's investigator who knows of inconsistencies in statements made by witnesses who will be called at trial and whose memories had to be refreshed in order to overcome those inconsistencies. It's the natural competitive nature of the adversary to want only the favorable evidence to surface at the trial. But it's the higher duty of the prosecutor under Brady to ensure that justice is done and that favorable evidence for the defendant is disclosed to the defense attorney. That favorable evidence under these circumstances are those inconsistencies so that the defense attorney can cross-examine the witnesses about those inconsistent statements. Brady conditioned that duty upon a request from the defense counsel so that the prosecutor was not obligated to prepare the defense counsel's case. However, that condition made the duty non-existent when the defense counsel had no knowledge of the favorable evidence. The natural response to such a rule was for the defense counsel to make broad general requests for all Brady material. The next step for the Supreme Court was to create a rule distinguishing between specific requests and general all Brady material requests or no requests. And the court drew a distinct broad line. The court said that when there is a specific request, the failure to meet that request and to provide favorable evidence to the defense attorney is rarely excusable. And the failure to do so, the court said, should be met with the same standard as when perjury is discovered after conviction. Therefore, a conviction must be set aside if there is any reasonable likelihood that the withheld evidence would have affected the jury's judgment. That was a strict, strong test, which would have encouraged disclosure. With regard to where there is no request or a broad general request, the court imposed a much looser standard. And that was, the standard for materiality was reversal was only required if the undisclosed evidence created a reasonable doubt of guilt that did not otherwise exist. Unfortunately, the next step that the court took was to discourage disclosure. And that was to combine those two standards and to eradicate the difference between a specific Brady request and no request at all. And so that in subsequent years, whether there was a specific request for Brady material or no request at all, the lesser standard has been applied, and therefore reversal will occur only if the undisclosed evidence creates a reasonable doubt of guilt that did not exist without that evidence. The net effect of this rule has been to encourage prosecutors not to disclose. The net effect of this rule is to result in years of post-conviction remedies where convicted defendants try to find out what was in the police files. And then if they succeed in finding out through discovery what was in the police files, the case is then reviewed under that lesser standard. Let me give you an example. In the United States versus Bagley, the government ignored a specific request and withheld information that the two principal prosecution witnesses had contracts with the Bureau of Alcohol, Firearms, and Tobacco for money for information. Instead, the government purposefully misled defense counsel by providing false affidavits from the witnesses that they had no promises for rewards. Rather than recognize the egregiousness of the prosecutor's behavior, the Supreme Court diminished the standard for evaluating that behavior. The court applied the lesser standard and said that the conviction would be reversed only if there is a reasonable probability that had the evidence been disclosed, the result would have been different. So while the Supreme Court has said that when in doubt, a prosecutor should disclose, the rules that have been constructed do not encourage disclosure and are not helpful. My friends and former students who are or have been prosecuting attorneys always tell me that I don't understand when we discuss these issues. They tell me that their caseload is overwhelming and that they don't have time to prepare their own cases, let alone prepare the defense attorney's cases for them. They also assure me that they're not in the business of convicting innocent defendants. While that last assurance is admirable, they miss the point. They're deciding who is innocent and who is guilty, which is not their role. And they make mistakes. And they're crippling the adversary system. Ohio is like every other state. Defendants have been convicted where evidence was withheld at trial and not disclosed until many years later. One such case is State versus Larkins, where the defendant was convicted in 1986 of a 1981 robbery and murder. For years, he tried unsuccessfully to gain access to police reports in his case. Those reports were not obtained until Bishop Alfred Nichols of Cincinnati filed a public records request with the Cleveland Police Department in 1999, and without objection from the prosecutor, received those reports. The police reports revealed that, number one, the description of the robbers given by eyewitnesses did not match Larkins. A description of, quote, road dog, the second shooter given by a potential suspect, Todd Hicks, did not match Larkin's as to height, skin color, or hairstyle. The police relied on a confidential informant. A witness who was present when the robbery was planned did not identify Larkins as one of the planners and said she saw both robbers after it was known Larkins had left town. Henderson, a co-defendant who turned state witness, named Larkins only after the police told her that Larkins was known by the nickname Road Dog. Henderson lied on the stand concerning her past criminal convictions. Moreover, it was also discovered that Henderson lied when asked whether the state had promised her anything in exchange for her testimony. She answered nothing. Although Henderson claimed that she was testifying without any promises from the state, the assistant prosecutor in the case wrote a letter to the parole board after the case saying that he had promised her, quote, he would do everything possible to get her off parole, unquote, because she was initially reluctant to return to Ohio to testify at trial. The Court of Common Pleas granted a new trial, which was affirmed by the Court of Appeals. When the case was remanded for a new trial, the state continued to argue for 4 years and to litigate the issue as to whether the police records were discoverable and that whether the evidence could be used at trial. During that 4-year delay, 2 more witnesses died and others disappeared. Finally, the trial judge dismissed the indictment, saying that was the only remedy for the delay, and the Court of Appeals upheld the dismissal order. As Barry Scheck will find out, even DNA tests do not necessarily bring the prosecution in this county and the state of Ohio to want to reopen a case and to re-examine the facts. Fred Luckett was convicted as a serial rapist in 1979. At trial, and for more than 20 years thereafter, Luckett maintained his innocence. A rape kit was done on the first victim, and a laboratory slide from that kit was found in the hospital 20 years later with the first victim's name etched on the slide just before it was to be destroyed. The slide was made from a vaginal swab smeared onto its glass surface just 90 minutes after the first rape. A leading DNA laboratory in Maryland determined that the semen preserved on the slide was not Luckett's. The victim of this rape, a 52-year-old widow, identified Luckett as the rapist. Rape kits were not done on the second and third victims, who also identified Luckett as the rapist. He was convicted at trial of the first 2 rapes and pleaded no contest to the third rape on the promise of no additional time. A motion for new trial was filed based upon the DNA test. At the hearing on the motion for the new trial, the state claimed that the DNA test was inconclusive because there was no reason to believe that the rapist had ejaculated or that the victim had not engaged in consensual sex with another person. However, at the original trial, the prosecutors introduced the slide to show that the victim was raped. That victim had died after the first trial. The victim's son testified that after she was widowed, his mother had had no social life and was very unlikely to have engaged in consensual sex. The judge who presided at the first trial granted the motion for the new trial. The state appealed. The Cuyahoga County Court of Appeals, by a vote of 2-1, reversed the motion, and Luckett remained in prison until he eventually was paroled. The issues that will be discussed today go to the very integrity of the criminal justice system. The prosecuting attorney has the key role in seeing that justice is done. The speakers and panelists you will be hearing represent a great balance. We have prosecutors, defense attorneys, professors. They're on the cutting edge of these issues. I want to thank them for being here today and for their participation in this symposium. The first panel will discuss the significance of Brady at plea negotiations. Since 90% of criminal cases end without going to trial, the significance of the Brady question has to be considered at this point. An interesting question, which you gentlemen may wish to discuss, is whether a prosecutor should be personally penalized for failing to disclose favorable evidence to the trial court and to defense counsel. Disciplinary action was brought against an assistant prosecutor in a nearby county who was prosecuting a child rape and molestation case. At a pretrial, the assistant falsely represented to the judge and the defense attorney that DNA test results had not come back, when in fact the assistant had been verbally told that the test results indicated that the semen on the boy's shirt was not the defendant but the complainant boy's. The assistant prosecutor also failed to inform the trial judge and the defense attorney during the plea negotiation and at the plea hearing and the sentencing that the boy had changed his story and acknowledged that the semen on his shirt was in fact his own and not the defendant's. The assistant prosecutor ultimately was suspended from the practice of law for a period of 6 months. The defendant ended up entering the same plea and receiving the same sentence. So the significance of the withheld information may or may not have been all that relevant. Let me introduce our first panel, distinguished gentlemen all. The first speaker on my right is our own Professor Kevin McMunigal, who is the Judge Ben C. Green Professor here at Case Western Reserve School of Law. Kevin's been on our faculty for 20 years. 20 years. Prior to joining our faculty, he was an assistant U.S. attorney in San Francisco. Before that, he practiced law with a law firm and clerked for a U.S. District Court judge, all in San Francisco. Kevin is the co-author of a new criminal law casebook and is a regular contributor, along with Peter Joy, to the ABA's Criminal Justice magazine. To Kevin's left is Professor John Douglas from the faculty of the University of Richmond School of Law and an associate dean at that law school. John has served stints as an assistant U.S. attorney. He has been in private practice. He was an associate counsel with the Office of the Independent Counsel for the Iran-Contra investigation and was the chief of the criminal section of the U.S. Attorney's Office in Richmond, Virginia. And to John's left is Scott Roger Hurley, Assistant County Public Defender, Cuyahoga County. In fact, Scott is a second-generation public defender. The law school's first clinical program worked with Scott's father, Roger Hurley, in the first public defender's office in Cuyahoga County. Scott currently represents indigent defendants in Cleveland Municipal Court. He has previously served in the County Public Defender's Office in juvenile, appellate, and felony divisions, and he is a graduate of our law school. Welcome, gentlemen. Thank you.
Thank you, Lou. Good morning. The focus of the rest of today's speakers, I believe, will be on Brady disclosure in the trial context. This panel, John, Scott, and I, by contrast, will focus on Brady disclosure and wrongful conviction in the guilty plea context. Supreme Court authority has long made clear that Brady applies at trials. All the Supreme Court cases up until Ruiz were trial cases. The same is not true with guilty pleas. The application of Brady to guilty pleas, whether or not there's a constitutional obligation to disclose exculpatory information at a guilty plea, has been and continues to be uncertain. It's varied in the lower courts. I first became interested in Brady and guilty pleas when I was in practice as an assistant U.S. attorney. Brady rights were always raised in the pretrial context. The defense lawyer always asked for Brady material. The prosecutors always said, we'll give it to you. And the judge always said, well, that's good, give it to him. But then the case would, 90% of the cases would plead guilty, and nothing would ever be said about the resolution of the Brady issues. The right to Brady would be left in limbo. Now, when I started writing about this, I would ask my friends who were prosecutors, I'd say, well, what do you think about Brady material guilty pleas? And the prosecutors would say, well, that's simple. You don't have to give it over. They waive that along with their waiving the right to trial. That's why we don't do anything. We don't make it explicit at the guilty plea. It's obvious that the right is waived. I would ask my friends who are defense lawyers, why don't you raise Brady material or clarify what happens to it at guilty pleas? They say, well, I don't clarify it because it's obvious that they have to give it to us. So there's this it's not a trial right, it's a right that applies to guilty pleas. And so there's diametrically opposed views from the prosecution and defense lawyers that I would talk to fairly routinely. And that their views, in fact, reflected the state of the law at the time. There were very few cases, and the cases divided. They were about 50-50, saying Brady did apply or Brady didn't apply. So it's a very mixed view. The Supreme Court doesn't address the issue until 2002. I left practice in 1986. In the intervening 20 years or so, a substantial body of case law from the lower courts started to develop, lower federal court cases and state court cases. And the strong trend among those, most of the circuits and many states held that Brady does apply to guilty pleas. There was also increased academic attention to it. I wrote about it. Professor Douglas wrote about it. A few other professors. A lot of student pieces about it. So the trend is moving toward applying Brady to guilty pleas. But in 2002, the United States Supreme Court in Ruiz addresses the issue for the first time and essentially does a U-turn. The law does a U-turn at that point. And Brady, the Ruiz case, at the very least, severely restricts application of Brady to guilty pleas. It pretty much says you don't have to give over any impeachment material, you don't have to give over anything having to do with an affirmative defense, and it leaves open the possibility that in a future case they might completely extinguish the right to Brady material. So I'll discuss Ruiz in a few minutes, but that's sort of the state of the law. It was developing toward applying Brady, and then in 2002 that sort of came to a halt with the United States Supreme Court decision in Ruiz. I want to discuss generally why I think there's a correlation between the accuracy of guilty pleas and Brady disclosure. First of all, the general factors that you'll be hearing about later today that contribute to erroneous convictions, many of those apply to guilty pleas. Examples would be rush to judgment. Prosecutors often make a quick judgment about guilt, and then they escalate commitment to that and are unwilling to re-examine that. That's a factor you see in guilty plea, erroneous conviction cases. The same thing is true in guilty pleas, and you see in some of these cases that even the defendant and the defense lawyer can arrive at an erroneous judgment about the defendant's guilt. I'll discuss some cases where I think that actually went on. Adequate representation is a theme throughout erroneous conviction cases, and that clearly applies in guilty pleas. If anything, I think it's probably more likely that there's less adequate representation in the context of a guilty plea because there's less financial incentive for the lawyer to prepare, fast-track pressures from prosecutors not to spend time on the case and quickly resolve it. Access to scientific expertise is a problem in guilty pleas just as it is at trial. So the two reasons I think that there are problems with accuracy have to do with the defendant's knowledge about whether or not they committed the crime, whether or not they're guilty, and secondly, sincerity. We tend to assume that the defendant has knowledge about whether or not they're guilty, whether he or she did it. Right? That's because we tend to think of conduct and internal mental state as the primary ingredients in criminal liability. They're the most vivid and most obvious. But if you look more closely at the elements that determine criminal liability, we often use many things other than conduct, other than internal mental state, things that the defendant would not necessarily know about. Two cases from the 90s that illustrate this, State versus Gardner's an Idaho case. It's a vehicular manslaughter case. The defendant was driving his vehicle. His vehicle crossed the center line, head-on collision with another car, and killed some people. It turned out later that he had been smoking marijuana before driving, so he was under the influence, although it wasn't clear how intoxicated he was. So the defendant pleads guilty to manslaughter. Well, it turns out that a witness following his car saw the front tire blow out. The reason the car jumped across the front line was not the guy's driving or him smoking marijuana. It was the front tire blew out. And the state police had this report and didn't turn it over to him before he pled guilty. So if you look at the case, it seems that the defendant and the lawyer and his lawyer and the prosecutor and the police all concluded that his driving is what caused the accident. In fact, the causation was the tire blowout. The case not only suggests that the defendant really didn't know what caused the accident, his lawyer had the witness's name and never called the witness to find out about what the witness had to say, so there was inadequate representation. There was also no examination of the vehicle, which would have revealed the condition of the tires. Right? Another case from Georgia, another vehicular manslaughter case. It's a rollover in a rainstorm. As a young woman, about 19 years old, is driving. The car rolls over. Someone's killed. She's charged with manslaughter. The police officer goes to the scene, gathers some data. He comes back and does an accident reconstruction. And the accident reconstruction, he says the young lady was driving 70 miles an hour in a 35-mile-an-hour zone. That's what the data shows. And that the road conditions did not cause the accident. Well, and he offers a report to this, and he testifies at the preliminary hearing. Well, it turns out that the expert is not actually an expert. He's actually taking a course to become an expert. Right? And he hadn't finished the course, and it turns out he flunked the homework assignment. His instructor re-examines his work and says, she wasn't going 70 miles an hour. You can't tell how fast she was going from the data you collected. And, in fact, the data indicates that the road conditions were, in fact, the cause of the accident, not her driving. So, again, there's a question about whether or not she was negligent, whether she was reckless, how fast she was driving. And they don't turn over the guy who comes in is his instructor and reviews the report, and they don't turn over that the guy's testimony and the report were erroneous. She winds up, essentially the defendant winds up concluding that I did cause the accident, it was my fault, I must have been speeding, and none of those things turn out to be true, so she actually, in both those cases, the defendant did not have adequate knowledge to determine their own guilt. A second reason why I think there's problems with guilty pleas and Brady has to do with sincerity. Just like we tend to assume that defendants know the critical facts, we tend to assume that a defendant would not plead guilty in open court with advice of counsel when they know that's going to be the basis for a conviction, unless they were sincere. But there are enormous pressures to plead guilty, even if you're innocent. We have all read about those: cost, publicity, stress, the sentencing differential. There could be enormous sentencing differentials. A case that illustrates this dramatically from the Innocence Project was a case from Texas. There was a young man who was charged with a rape and murder in a Kentucky, I think it was a Kentucky Fried, no, a Pizza Hut, in a Pizza Hut chain. He worked in another Pizza Hut. Not only did he plead guilty to having done it when he hadn't done it, he also agreed to testify against the co-employee who was innocent. So he goes to jail himself in order to avoid the death penalty, and his co-employee goes to jail. Years later, the actual killer has a religious conversion. He sends then Governor Bush a letter saying, "I did it." Nothing happens with that letter for another 4 years. Eventually, the Innocence Project gets involved. They do a DNA test, and it turns out he didn't do it, and the guy he testified against didn't do it either. That's Ochoa. Ochoa actually winds up getting, that was the Wisconsin Law School Innocence Project that wound up getting him freed. He's now a student at Wisconsin Law School and working in the Innocence Project. The man he testified against was not so lucky. He was assaulted in prison, had serious brain damage, and will be institutionalized for the rest of his life. So Ochoa is a good example of a case where someone who's innocent pleads guilty. It shows that the innocent people do plead guilty. There's another case from a reported case in which from Louisiana, where the guy pleads guilty to drug offenses, and it turns out the police had information that he was in jail in the local jail at the time that this undercover officer testifies he was out on the street selling drugs to folks. So he pled guilty. In part, in that case, one of the incentives was that he had an alibi. Well, there were two offenses. He had an alibi for one. He was in jail for the other. His fiancée and his mother testified in his behalf, and the prosecutor threatened to bring perjury charges against all of them if he didn't plead guilty. So there was enormous pressure there. And it was a case in which the guy pled guilty regardless of his actual innocence. So those cases illustrate both knowledge problems and sincerity problems in guilty pleas. I actually think that if a prosecutor gets what's now considered Brady material, that's material that's likely to raise reasonable doubt, you're not going to win the case, right? So the most likely thing I think the prosecutor will do is dismiss the case. So I think many cases with the Brady information wind up being dismissed. If they're not dismissed, I would think that what the prosecutor would do is you could take it to trial, but then you have a constitutional violation for sure, because Brady clearly applies to trials, and you're much more likely to get discovered because of the trial process. It seems to me the place where you would think most Brady cases would go would be into plea bargaining. So I actually think that's where you're likely to find Brady cases, most of them. There obviously are ones that go to trial, as we'll learn about later today. But I would think that they would either be dismissed or you'd find a lot of them in the guilty plea context. The Ruiz case, I want to talk about that just for a few minutes. It sort of tells you what the current state of the law is on this. As I mentioned a few minutes ago, there's a trend in the circuits for Brady to be extended to guilty pleas. Most of the circuits that held this, there was a split in the circuits, but the majority were in favor of applying it. And the Ninth Circuit was one of those. So in essence, what these courts had held is there's no implicit waiver of Brady material during a guilty plea. Right? So in response to that, what some of the prosecutors started doing, the Southern District U.S. Attorney's Office, started then saying, okay, you don't implicitly waive Brady, but we are now going to make a condition of the plea agreement that you expressly waive Brady. Right? We'll give you a 6-month reduction in sentence if you waive your right expressly to Brady material. So that goes up to the Ninth Circuit, and the Ninth Circuit says that's unconstitutional. This is an unwaivable right, and that's the context in which the Supreme Court gets the case. So the Supreme Court could have limited itself to just saying approving express waivers, right? But it did not. The language of the case goes on to say that, at least in the context of affirmative defenses and impeachment, there's no right to Brady material in the first place. So there's nothing really to waive. There's an implicit waiver. In the case, the case completely dismisses concerns about accuracy and guilty pleas. There's only one sentence in the case having to do with accuracy and impeachment, and it essentially says we can rely on Rule 11 to assure that guilty pleas are accurate. And interestingly, this case is decided a year after the Ochoa case, which received considerable publicity. The Supreme Court seems oblivious to that. Also, if you look at on the Innocence Project website, this case is decided in 2002. The number of exonerations reaches a high point in 2001, right before the Ruiz case is decided, and the Supreme Court completely dismisses any concern about accuracy. When it comes to affirmative defense information, it completely dismisses any value for Brady disclosure. The case completely ignores the lower court authority supporting Brady. It actually states they can't find any lower court authority dealing with this issue. Now, that's technically correct if you're thinking about the express waiver issue, but it completely ignores probably the most glaring error I noticed when I read the case was that it failed to cite either my article or Professor Douglas. So right there, it's a res ipsa loquitur. All right. Another thing I think that's troubling, two other points I'd like to make is it seems like the court is narrowing its conception of innocence. In the fast-track agreement in Ruiz, the prosecutor did say, we won't give you impeachment information, we won't give you affirmative defense information, but we will give you information if it establishes your innocence. Right? Now, that definition of innocence completely excludes any principles of justification and excuse. Right? It says self-defense, provocation, any of those are irrelevant to it. So it's adopting a very narrow definition of innocence. The other thing I think is troubling is when you read the trial cases, Brady, as Professor Katz pointed out, over the course of the years, the Supreme Court has narrowed the Brady right dramatically. But at least in those cases, they say to prosecutors, look, we're not going to impose a very stringent constitutional duty, but you have another duty to turn this over. And they over and over again, they keep saying, you should be turning this over. There's this exhortation in these cases. Some people have called this a sort of subconstitutional side effect of Brady, to tell prosecutors that they ought to be turning it over, even if it's not a constitutional obligation. In Ruiz, you don't find even a suggestion of that. There's absolutely not. I would say that the court's posture in Ruiz is basically receptive, or I would say even supportive, of prosecutors not turning over Brady material. Why don't courts get the connection between disclosure and actually guilty pleas? Ruiz is an example, and lower court cases have had this problem as well. One reason I think is that the language of Supreme Court cases doesn't prompt an inquiry about accuracy for guilty pleas. The court tends to look at guilty pleas in terms of whether or not they're voluntary, intelligent, and knowing, and that language doesn't prompt an accuracy concern. They see guilty pleas simply as waivers of rights, not as a process of accurately resolving factual guilt. They ignore that dimension of a guilty plea. There's also, I think, the unexamined assumptions about knowledge and sincerity that we talked about a few minutes ago. And then finally, I think there is a reluctance to let factually guilty defendants avoid conviction in cases in which the evidence is too weak. So in other words, the Supreme Court, I think, is giving a green light to using guilty pleas to do an end run around the burden of proof standard of beyond a reasonable doubt. I'd like to conclude by just saying where I think disclosure law may be heading in the next few years. I think the prospects of Brady v. Maryland being the source of a prosecutorial duty to disclose in the future in the guilty pleas, the prospects are dismal after Ruiz. Right? I think that the Supreme Court may be likely to hold that there's absolutely no guilty pleas. That may be extinguished. A more promising avenue is the creation of a statutory duty. In response to Ruiz, some defense organizations have proposed modification of federal rules of criminal procedure 16 and 11, having to do with discovery and guilty pleas, saying there should be essentially a statutory duty to turn this over. And that proposal is currently in front of the Federal Rules Committee, and that seems to me the most promising route now to enforcing prosecutorial disclosure is to do it via statute. Another avenue, which some lower courts after Ruiz have adopted, is there are two famous Supreme Court cases with the Brady name in them. often referred to as the Brady bunch. Brady versus Maryland and Brady versus United States. Brady versus Maryland, after Ruiz, is hard to use as a basis for a disclosure obligation. But what some lower courts have done is, instead of using Brady versus Maryland, they turn to Brady versus United States. And in Brady versus United States, there's some language that says, if the government has misrepresented something, that means that the plea is not voluntary. And essentially what the courts are doing is, they say, when the prosecutor provides a lot of inculpatory information, which they typically do, they're often not required to, but prosecutors tend to be very generous with inculpatory information because they want the guy to plead guilty. Right? There's a self-interest. When they give inculpatory stuff and hold back exculpatory stuff, the combination of that is seen as a type of misrepresentation. There's a recent First Circuit case that goes this route. So actually, I think Brady versus United States, focusing more on prosecutorial misconduct rather than accuracy, may be a route that courts pursue in the future to impose a prosecutorial obligation duty. So now I'll turn things over to Professor Douglas.
Good morning. Thanks for having me up here from Richmond. It was a little warmer there, but it's wonderful to be here. I know this is an important topic because it was part of a Law & Order episode. Some of you may have seen it. They actually had a Law & Order episode about a prosecutor who failed to disclose Brady material during a plea negotiation, and the guy entered the plea, and of course right there on television about 10 minutes later the defense attorney learned that he had been snookered and was not happy. I actually think that episode reflects at least one of the reasons why most prosecutors, most of the time, actually do disclose Brady material in the course of plea negotiation, and that is because there is a tomorrow. And that tomorrow oftentimes involves meeting that same criminal defense attorney in the courthouse or on the street and dealing with him or her again. And having failed to do it the first time puts you in a pretty difficult position to deal with that attorney the second time. So in a way, the process is, shall we say, self-policing. One of the other reasons that I think Brady disclosure occurs quite often, even if the rule is not explicitly applied to plea bargaining, is in the world of guideline sentencing. So many of the facts that are discussed and debated between defense attorney and prosecutor in the course of plea bargaining are relevant to sentencing, very directly relevant to guideline sentencing. And at least I was a prosecutor for about 10 years, mostly in a guideline sentencing environment in the federal courts. And quite often, it turned out to be the case that both the defense lawyer and the prosecutor were in fact searching for, shall we say, mitigating evidence to present to the court to justify a plea that would put you within a lower guideline range and justify the plea agreement to begin with. So it's not all that unusual, in fact, that defense lawyer and prosecutor are aligned in their interest in what you might call Brady disclosure ultimately to the court. Having said all of that, I will agree, certainly with Professor McMunigal, that a world that relies solely on the good faith of the prosecutor in this realm is a dangerous world because there are folks who are less concerned about tomorrow's plea negotiation and maybe even less concerned about some of the representations that may go to the court. And so rules are important because if this is an obligation that is as important as I believe it to be, there needs to be some way to enforce it. Professor McMunigal is right, I think, when he says that disclosure in the plea bargaining process is important to make sure that innocent people are not coerced into pleading guilty. I believe that myself. In any negotiating context, and all of us who have been involved in negotiating settlements, whether it's a plea bargain or a civil case settlement, it certainly is true that information particularly information that helps us determine the likely outcome of a trial, the risk that you face when you go to trial. That kind of information is critically important to someone who is bargaining over settling a case, criminal or civil. And disclosure of information in that process makes bargains, shall we say, more accurate. They more accurately mirror what's likely to happen at trial, and that's a good thing. I also think it's true that non-disclosure disproportionately harms innocence. If we assume, and this certainly is not true in every case, as Kevin has pointed out, but if we assume as a general matter that guilty defendants know more about what happened than innocent defendants, I'll call them innocent, clueless defendants, then disclosure is most important for those people. And if that's true, then rules of disclosure in plea bargaining, at least, are one way to reduce the likelihood, it's not perfect, but a way to reduce the likelihood that an innocent person is coerced into pleading guilty. And so I agree from the start that rules which would promote more disclosure and disclosure of exculpatory evidence in the process of plea bargaining are desirable and important, and we should seek them. And there are some examples, by the way, in local rules of some federal courts that do exactly that. Where I think I may part in my views from Professor McMunigal is my feeling that Brady, at least Brady as it has been interpreted in the plea bargaining context by the lower federal courts and some state courts, that Brady may not be the right rule. It may be a rule that's ill-suited, shall we say, to the process of plea bargaining. And I even more strongly believe that Ruiz, the Ninth Circuit's case that made it to the U.S. Supreme Court, resulting in a ruling which doesn't quite yet extinguish the issue but comes pretty close to it. I also think Ruiz was clearly the wrong test case, at least from the point of view of the defense bar, to present this issue to the U.S. Supreme Court. And I'll make a couple of quick comments on Ruiz, and then I'll tell you at least what limited role Brady may still have in the plea bargaining context after Ruiz. As I said, from a defense perspective, the Ruiz case was a terrible case, a test case to present Brady to the Supreme Court. I have to believe in the Solicitor General's office at the Department of Justice, when they saw this case come in, they must have had a party and said, this is the perfect Brady case for the government to take to the U.S. Supreme Court. That's partly true just because of the facts of Ruiz, and the opinion, I think, is reproduced in your materials. You can take a look at it at the break, perhaps, if you haven't already. The facts were terrific facts for the government. Unlike the typical Brady case, where there's undisclosed exculpatory information that comes to light later on and it's the government's fault, unlike the typical Brady case, in Ruiz there was no suggestion that there was any actual Brady material, any actual exculpatory evidence. And there was no suggestion that Ms. Ruiz was innocent. She didn't claim to be. She got caught red-handed with 30 keys of drugs in her suitcase. Not a favorable position to be in. Not only that, she was offered a plea bargain by the government, but she rejected it. And she rejected it, of course, because the government, in the course of that standard form plea proposal, asked her to waive her right to receive certain types of Brady material, that is, information that might impeach government witnesses. But she rejected the plea bargain, and her claim through the courts of appeals and to the United States Supreme Court essentially amounted to an argument that she should have been given the benefit of the bargain that she rejected. If you put all of that together, you can see why this case was in trouble and ultimately resulted in the 9-0 decision that came out of the U.S. Supreme Court. The other reason I think that Ruiz turned out to be a terrible test case for Brady in the Supreme Court is because of the way the issue was framed by that waiver. First of all, the waiver dealt with impeachment information, which was kind of like a fastball down the middle of the plate for the government. When it comes to disclosure in criminal cases, the government historically, and oftentimes for good reason, has had particular sensitivity and has resisted more fervently the idea of disclosure that relates to government witnesses. And the justification for that reluctance is the safety of those witnesses. It is true, unfortunately, that there are plenty of examples where witnesses, federal or state, particularly in violent crimes, often in drug and organized crime situations, witnesses are harassed, intimidated, threatened, or worse. And the government takes that seriously. And as a result of that kind of concern, the discovery rules in criminal cases are really quite limited when it comes to discovery pertaining to government witnesses. The Jinx Act, for example, in federal courts provides that the government need not, if it chooses, need not produce the prior statements of government witnesses unless and until they actually get on the witness stand to testify. We can debate whether that's a good rule. And it's also true that that's a rule that is essentially voluntarily waived by the government in most cases. But it doesn't really change the point with respect to Ruiz. Ruiz was talking about a particular kind of Brady material that is most sensitive to the government and occasionally is sensitive for a very good reason. The other problem with the way Ruiz was framed is that because it was a waiver case, the issue that came to the Supreme Court was not precisely whether there's a Brady right in plea bargaining, although Kevin's right, the court actually framed the issue more broadly than it had to. The issue is whether it's a non-waivable right. In other words, a constitutional mandate that applies in every case, even when the parties might agree that it didn't apply. And because it came to the court as that kind of constitutional mandate, a non-waivable rule requiring disclosure of impeachment evidence, the government was really in a terrifically favorable position. Essentially, all the government had to show to the court was that there are some cases where the rule ought to be waivable. There are some cases where it's important enough to withhold information about government witnesses that we ought to be able to do that until trial or the eve of trial. And so because of the context, I think, of Ruiz, the opinion perhaps is less surprising than we might think against the backdrop of the Brady problem. Aside from the facts of Ruiz and the context in which the issue was raised, ultimately I think the doctrine, the constitutional doctrine that the court focused on in Ruiz was problematic for the defendant. And this is why. Because the Supreme Court typically looks at a guilty plea as a waiver of most everything. You stand up in open court, you look at the judge, sometimes you're sworn, and you say, I did it. And oftentimes the judge asks you a little bit about the facts, and then you say how I did it. And because guilty pleas are viewed as waivers, when we try to apply Brady in the plea bargaining context, the first hurdle, the first problem is that guilty plea and that waiver. And in order to overcome that waiver doctrine, the Ninth Circuit and a number of other courts had begun to hold, along with a long line of cases that says waiver is only valid, the guilty plea is only valid if it is voluntary and knowing. Sometimes the word is intelligent. And the Ninth Circuit and other courts had interpreted that phrase, voluntary and knowing, ultimately to mean informed of Brady-like evidence. And so the doctrine that finds its way to the Supreme Court essentially turns Brady in the plea bargaining context into a right of informed choice, the right of a defendant to make an informed choice to plead or not to plead. And despite perhaps the sort of superficial appeal of that doctrine, it runs into a lot of other problems. First of all, it runs into the Brady versus United States precedent that Kevin talked about. and amongst other things, that the United States Supreme Court in Brady versus United States says, there really is not a right, a constitutional right, to know everything about the government's case before you plead guilty. There just isn't. Sorry. So there's precedent in the way of a right of informed choice. The other problem is that turning Brady into a right of informed choice gives it too much to carry. It's a right that Brady cannot accomplish, and it cannot accomplish providing defendants with truly informed choice in plea bargaining because of the other piece of the puzzle. Brady deals only with exculpatory information. The rules of criminal discovery are quite limited with regard to inculpatory information. And quite often the value of exculpatory information, particularly impeaching information, is limited or minimal unless you know the rest of the story. For example, the government's disclosure that witness Smith has a prior criminal record and may have been given incentives to testify is not particularly meaningful to a defendant who doesn't know what Mr. Smith is going to testify to at trial. And at least in the current world of criminal discovery, the government doesn't have to tell what Mr. Smith is going to testify to when he gets to trial. The Supreme Court in Ruiz used the term random, and I think that's correct. The court says, as a rule, in effect, as a rule of informed choice, Brady provides, at best, random protection in plea bargaining. And so that brings me to the end of my story, which is good because I'm about to the end of my time. Funny how that works out. Actually, usually for us law professors, it doesn't work out. We go, well, never mind. Which leaves the tough question that Kevin proposed. Is there still any shred of hope for Brady in the plea bargaining context? Does it have a role? And if so, where and what? And is the court likely to recognize it? I think the likelihood that the court's going to recognize it may be slim. But if the court is going to recognize Brady in the plea bargaining context, it seems to me that it's not likely, and Ruiz pretty much says this, it's not going to recognize it as a protection of the defendant's right to make an informed choice in plea bargaining. It's not going to be a rule that focuses on whether the defendant made the right choice or not. The question that the Ninth Circuit asked and that the lower federal courts had been asking in Brady context was this: does the undisclosed information, the stuff that should have come out during plea bargaining and didn't come out until somebody found out about it after the fact, is that undisclosed information important enough that it would have changed the defendant's mind and he would have rejected the plea? That's the way Brady has been applied in the plea bargaining context, and that's what the U.S. Supreme Court rejected. And by the way, that's a tough place to try to analyze Brady, because what you're really doing is you're getting inside the mind of a defendant and defense lawyer, and there's no record a lot of times of what that is and what the information meant or might have meant. At trial, Brady essentially it's a safety net or safety valve, if you will, for innocence. Brady information is material when reviewed after a jury verdict if it raises a reasonable likelihood that the outcome of trial, a guilty verdict, is wrong. In other words, if the information provides, I think as Kevin said, a reasonable doubt that didn't exist before. It is an outcome-based, a result-based test of materiality. We look at the verdict after the fact and we try to figure out whether it would have been different in effect. Okay? Very different than the test that I just talked about in the plea bargaining context. I think if Brady has any hope of surviving in the plea bargaining context, it will be as a doctrine that asks a different question than the Ninth Circuit asks. It will be as a doctrine that asks, after a plea of guilty, pretty much the same question that we now ask after a trial. And that is, did the undisclosed and now learned information, is it important enough? Is it significant enough to convince us that an innocent person has pled guilty. And of course, you can decide what that standard is. I'm not suggesting the same standard that the government did in the Ruiz case, that the defendant has to establish his innocence. But it seems to me the question ought to be, and this is to use the words of the Supreme Court in the trial context, whether the undisclosed information undermines our confidence in the result of the plea proceeding, that is, the ultimate judgment of guilt. And of course, I also think that once the plea has been entered and the court is making that assessment, it has to take into account the fact that the guy stood up in open court and admitted his guilt and whatever facts he was prepared to admit along with it. Which means at the end of the day, of course, under that standard, that Brady is not going to free a lot of folks. It's not going to, open the jailhouse doors to folks who have pled guilty. But I would suggest, frankly, in the guilty plea context, that it shouldn't. That it shouldn't be a doctrine, as the Ninth Circuit applied it, that for the most part entitles defendants to a second bite at the apple, which usually amounts to a better deal. It should be, in the plea bargaining context, effectively the same thing it is after trial, which is a safety net for innocence. And I think I need to stop. Thank you.
Good morning, everybody. Again, my name is Scott Hurley, and I'm a public defender here in Cuyahoga County. I first want to say thank you to Case. I graduated from this law school, I think before this room actually existed, back in '94. And I am certainly encouraged by Professor Katz and the other panelists, because no matter how you look at this, this entire symposium is really an effort at sort of paradigm shifting about how we look at the criminal justice system, and it's a consciousness-raising endeavor, and I'm grateful to be a part of it. I am going to transport us here for just a few minutes. I guess 10, 15 minutes? What do you want to do? Okay. Transport us here to the Justice Center on what may appear to be something of a frolic and detour, but I promise I'll connect up here in a moment. If anybody's been to the Justice Center, you'll know that there is public art at its entrances. We remember there's that giant portal at the Justice Center. It looks like a big bent paper clip there. And some think of that as a giant vortex hole that sucks people in and never lets them out. And that may be one legitimate interpretation of that work of art. On the north side of the Justice Center, there are statues by an artist named George Siegel. And they are sitting on a park bench, and they are giant. They're human size, and they're people sitting there, ghastly, ghostly, white people seem to be just waiting forever. It's another interesting comment on the justice system, I suppose. But the one I really want to talk about is the one that I'm not sure, unless I've babbled on to you about this before, most people in this city, let alone this room, don't know about. And that is the work of art that is at the west entrance of the Justice Center. Now, that entrance was closed after September 11th. You can't get in that way. And therefore, people never bother to traverse what is a work of public art there. That work is by an artist named Richard Hunt. And he was born in 1935, graduated from the, I think, the Chicago Institute of Art. He was the first African-American artist to have a retrospective at the Museum of Modern Art in I believe, New York. A renowned artist with many, many public installations. But this particular one is unusual, and I want to describe it here for a moment. It's actually two pieces. And if you are walking up the stairs to the entrance, there's a taller portion of it that looks like twisted metal, things hanging off the top. And then over on the other side, that you would pass through these two to get to the entrance of the Justice Center, is a platform with another kind of smaller piece of chunk of metal on it. And you could look at this for hours and just think it's a chunk of metal. But I see it differently, and I think that if anybody bothers to take a look at it, you'll see what I see. And that is, in the larger, taller part of this work of art is actually, it's a female form. And you can tell that by the bust and the V-neck that is there that I noticed. But the thing about the top of it, it has no head and no arms, but there's a huge weight that hangs over its front, almost like a shovel. And the back of it, seems to be no countervailing balance on the back of this statue, until you realize it's about 15 feet away. If you were to take what's 15 feet away and put it on the top of what exists there, you would have balance over this female form. And it is Dame Justice. It is the scales of justice. And they are forever in this work of art separated from one another. An interesting comment on the criminal justice system, especially when you got to walk through it to get into the building itself. By the way, the Cleveland Museum of Art website describes this particular work of art, which is called Sentimental Scale, as not on display. There's no placard or anything that tells you what it is. So I'll stop talking about that for a moment and move on here. Let's talk about something as timely as today's headlines. I mean, the Duke case, I think, is something that has captured many people's attention. 60 Minutes a couple of weeks ago, I think it was James Coleman, who was a professor, I think at Duke, though I could be wrong about that, was asked, what does it mean that a prosecutor would choose to not turn over evidence of genetic material that is unrelated to anybody suspected in the case? And Coleman's answer was, it shows an indifference to justice. I mean, there's no other way to put it. It means that the person that chooses to not turn over that sort of information to the defense isn't interested in justice and has some other agenda. And whether that agenda is a competitive adversarial one or an effort to make themselves look stronger or whatever, it shows an indifference to justice. And I think that that's an important idea here as it relates to this entire notion of the exculpatory evidence issues that this symposium addresses. I have had the occasion to be involved in discovery on the felony side, and in many instances it was a rather depressing endeavor where the prosecutor would sit down with his file and, like the kid at McDonald's trying to make sure nobody else takes his fries, he would read you what he wanted to read you, and it was up to you to just kind of go from there. It's go get your own exculpatory evidence kind of a thing. I will tell you that in my current capacity, right now I'm doing mostly high-volume stuff in Cleveland Municipal Court. The way that our office operates is I work with the same prosecutor in the same room for several months at a time, and that's a totally different interaction that I have with prosecutors, because frankly it means that I have the ability to develop relationships with them, and I think that in and of itself is sort of a way to avoid the sorts of problems that arise in these situations. If you establish a reputation as an attorney, a defense attorney who is at the very least fair-minded and reasonable and is not going to turn this into some sort of ugly process of the sheepdog and the coyote dropping anvils on each other, as long as the prosecutor understands that my aim is true, I will tell you that I have very little problems, as far as I can tell, although hindsight is always 20, as it relates to not getting the sort of evidence that one would expect to get. I wonder if, when we look at the sorts of opinions that have been discussed today, for example, Ruiz, I think as a defense attorney I would suggest it's a disappointing ruling. And I wonder if, and maybe somebody in this room knows this, I wonder if Breyer or Thomas, who wrote a dissenting, or I should say a concurring opinion in that matter, have ever stood next to somebody that was charged with a crime. And I suggest that had they had that experience at some point in their lives, perhaps that opinion would have been written differently. Solutions. I mean, I adopt and incorporate everything that these two distinguished gentlemen have said, and obviously I am less of an academic, and as somebody mentioned to me today, asked me, so what's it like in the trenches? And my response was, stinky. It really is stinky. And frequently heartbreaking too. But I mean, it's a difficult place to see injustice with such frequency. Solutions, though. I already mentioned one, and that is an endeavor on every attorney's behalf to find some personal integrity and a reputation that establishes you as somebody who no prosecutor is going to want to mess with, and certainly no prosecutor is going to want to hide stuff from. The time is ripe for open discovery pursuant to an amendment to Criminal Rule 16. I believe that is still in the public comment stage, or is it done? No. All right. Well, okay. It tells you how informed I am about these sorts of things. I don't know. I get everything I need from my prosecutors right now, so I'm another thing that I wanted to mention, some of us may have heard of the flying spaghetti monster. I'm going to mention the 3D exculpatory evidence machine. And the 3D exculpatory evidence machine is the preliminary hearing room, which happens to be in Cleveland Municipal Court. And I have practiced in that room many times. And just to refresh everybody's situation here, that is in the city court where the bind-over process occurs for the felony and the common pleas court system. But there's the right to a preliminary hearing. There's the right to cross-examine witnesses at a time that is contemporaneous with the allegations involved. And it is really an opportunity to lock testimony in, to find out what exactly someone's perceptions and sworn testimony is at a time close to the offense, because in the vast majority of cases, the trial may not take place for another 6 months or whatever, and by then, of course, everybody has kind of made up their own mind about what they're going to say in trial. And the notion of a preliminary hearing transcript to really keep people honest, I think is really a profound way to make sure that the criminal justice system is working properly. It is an essential check or balance, whichever one you want to call it, in the process to make sure that the criminal justice system is working fairly. The problem is, unfortunately, is that in many cases the prosecutor's office chooses to indict somebody for the grand jury process before the person gets their preliminary hearing. So in essence, you have an exchange of a secret, non-adversarial proceeding that results in indictment. That is exchanged for what would have been an open, public, adversarial process that would have led to the same result. And it's, you know, I waived many preliminary hearings for a variety of reasons, but I think in the grand scheme of things, the more preliminary hearings that occurred in our society, the more likely we could all have some faith in really what sorts of prosecutions are occurring in our jurisdictions. I happen to be a participant of something called the 3 R's program. Cleveland Bar Association has this thing where we're going into high schools throughout Cleveland, and we're just educating high school kids about their rights, and not just telling them not to break the law. We're explaining to them what their rights are. And somehow, some way, I hope that 5-10 years down the line that this might actually kind of change the discussion about the fairness of our criminal justice system. As long as people are informed about their rights and their choices. I would also propose that at some point in the next 5-10 years, maybe there would be a situation in which people would be advised of their rights almost immediately upon their arrest. That is to say, they're sitting at a district someplace. We've got 6 districts in the city of Cleveland where people are held for felonies. If, in fact, there was someone to not only advise people of what their rights are and their choices are and their rights to remain silent at that stage, but also check for mental health issues, drug and alcohol issues, all those sorts of things should be done immediately upon someone getting into the meat grinder, as opposed to a month later or 3 months later. And I think on some level that, too, might ultimately result in a raising up of the criminal justice system. I mean, the Brady issue and the plea issue, I realize I haven't focused much on that, but I would point out, it really is the symptom of a grander disease. And I hope that we have the ability to work towards trying to find solutions to that grander disease. Professor Katz mentioned the higher duty that we all have, the prosecutors have, above and beyond any sort of adversarial process. And I think that applies to everybody, not just prosecutors, but judges and defense lawyers as well. I'm going to stop. I will tell you that I have spent my life and my career since graduating here with the notion that you judge a society by how it treats the least among its citizens. And we got to make sure that we treat those people justly and fairly and with dignity. And I thank you for your time.
Thank you for your comments. We'd like to have a few minutes of questions. If oh, there we go. Just please wait for the microphone because we are webcasting. Thank you.
I'd like to direct this question to Scott Hurley. With respect to the Supreme Court's decision in Ruiz, what have you found as a practical matter in your work and that of prosecutors' work, the effect of that has been? I mean, you talked about how by establishing good working relationships with the adversary or the opposition, you're able to skirt some of these issues, but beyond you, what do you see as a practical matter, the impact of Ruiz?
I haven't seen much impact of it at all, actually. I mean, if Ruiz stands for the proposition that, the prosecutor doesn't have to disclose in the context of a guilty plea, I mean, that's one of those sort of hindsight's 20/20 sort of things anyways. I mean, you would never really know. I mean, I still have a first pretrial where I am talking to the prosecutor, at least at this stage of the game, and frankly, I'm getting basically open discovery as long as I have a good relationship with that prosecutor. So, I mean, I can't speak it from my own perspective here what sort of a consequence Ruiz has had, but that doesn't change the fact that it's troubling. I think my point is that it is really addresses more a symptom rather than the disease of a grander problem.
Question for the panel. You suggested that Ruiz was wrongly decided, and I agree with you, but it was unanimously decided, and I'm wondering why that would be when some justices who you might expect to be more inclined to look through the problem and consider the potential for abuse nevertheless reached a 9-0 decision with only Justice Thomas concurring. I wonder if, given as has been correctly noted, the great majority of these cases are pled out rather than go to trial. There's some concern that if exculpatory information were disclosed during the pretrial stage, we would have many more trials, and the system might very well break down if everybody to whom some exculpatory information is revealed insisted upon a trial.
Well, I think the answer to your first question is what John talked about, the way the case was. You can look at the case narrowly as just presenting express waiver in these particular facts. They were terrible facts. What disturbs me is that the Breyer opinion goes on to reach issues much broader than that. So I would say that it was the way the issue was framed that. And then in the Breyer opinion, he suggests, he bought, I think, hook, line, and sinker, I think a totally implausible argument from the government, which is if Brady was applied to guilty pleas, it would require a radical change, and the government might abandon guilty plea negotiations. Well, that hasn't happened in any of the states that required Brady. None of the lower circuits that required Brady. It never came to a grinding halt. And I think that overestimates how much, I mean, Brady material is a very narrow category material. It doesn't exist in that many cases. A lot of those cases would be dismissed. So I think that idea that it's going to change plea bargaining is just completely implausible. And it's one of the problems in the opinion, he just overstates. For instance, when he's referring to Brady material, he refers to all discovery as if everything would have to be turned over, as if it's requiring Brady is tantamount to open file discovery, which it's not. As the Supreme Court, as Professor Katz pointed out, the Supreme Court's defined it very narrowly. It doesn't rise in that many cases. So I think that conclusion it's not borne out by what happened in the circuits.
Well, as I said earlier, I actually think Ruiz, on the narrow issue that was framed before the court, was correctly decided. And for the reasons that I explained before, it was a terrible test case for Brady in the U.S. Supreme Court. It was a great case for the government on those facts. But I think the real danger of Ruiz is more symbolic, and that is the terrible danger of the opinion is that prosecutors generally might regard it as a stamp of approval by the Supreme Court of the notion that they don't have to turn over exculpatory information. If we begin to treat it that way, then what will happen is the right case will come to the U.S. Supreme Court and they'll put the issue in a very different light, and we may get a different kind of result.
I suppose a cynic might say that it appeared that the fix was in and that there was just no way that this issue was going to go the other way in front of the United States Supreme Court. But as a practical matter, it's also possible that that the United States Supreme Court's decision. The thing that bothers me most about it is the fact that, I think, as Professor McMunigal points out, I mean, there were so many issues, so many cases that addressed similar issues, and they were completely ignored in the opinion, and that is certainly troubling. I don't have any other explanation for it other than to say, we need to make sure that issue is looked at as a partial component of a lot of other issues that hopefully will be addressed in the next 10 years.
It seems to me that even if you're sympathetic to the view that a prosecutor should be disclosing exculpatory evidence in a case that eventually is going to be pled, it seems to me that doctrinally the problem is the court refuses to divorce a governing normative standard for prosecutors acting in a forward manner from the standard that they use as an appellate court deciding whether to reverse. And I think, John, you touched on something important when you said, okay, well, what does materiality look like when you're talking about a guilty plea? It seemed to you, and I think that's right, the question is, would the defendant have pled if he had been given the exculpatory evidence? And it seems to me that it's impossible for an appellate court to be able to determine that because, first of all, there's the subjective values of a defendant that we have no way of knowing, which you touched upon. But second, there's the absence of a trial record. You don't know the strength of the case. The appellate court wouldn't be in a position to say, well, how good of a deal did this person get? What was the normal deal that people would have gotten? Because maybe the failure to disclose was sort of taken into account. Maybe they got the benefit of that, even if there wasn't an express waiver. And I'm wondering if that's, I just don't know how you get around that, and I don't know if maybe that's why, John and Kevin, you both eventually started saying maybe it's not a Brady issue, it's a different issue, the other Brady issue or something like that. But how do you deal with that? How do you weigh materiality when there's no trial record?
Well, you put your finger on what I think is one of the toughest problems with Brady, and that is, as a rule of discovery, it's a prospective obligation. It's what the prosecutor is supposed to do as we get ready for trial looking forward. But as a matter of enforcement, it's always enforced, almost always enforced retrospectively, which means after there's been a finding of guilt at trial, or in the plea context, after a defendant has stood up in open court and said, I'm guilty, which is one of the reasons that the standard for materiality that we've gotten from the Supreme Court is so high, because the interest in discovery at that point conflicts with the interest in finality. And so the standard diminishes. In the guilty plea context, I would suggest it's even tougher. And it's doubly tough in that context because you don't, as you say, you don't have a record against which to compare it, which is why the informed choice doctrine of the Ninth Circuit is doubly troublesome. You've got finality to overcome, you've got the guilty plea to overcome, and you've also got no real record that helps you answer the question, why did he plead?
I would just briefly just say that, I mean, whether it's material or not is just as much of an elusive issue as whether it's exculpatory or not. I may find something exculpatory that the prosecutor, for whatever reason, just would never, in their mindset, ever see as something exculpatory. And obviously we're not talking only about factual innocence exculpatory evidence. I'm talking about impeachment stuff. They got lousy witnesses, and they don't tell me that they know that they're lousy witnesses, as well as affirmative defenses. So it's every case is different, and it's a matter of kind of muddling through every single case.
I think the first point you make that in all these problems, there's an interesting and difficult counterfactual analysis you have to do. What would have happened? And we can either focus on a phantom juror, how would the juror have reacted, or the defendant, how would the defendant have felt differently about the plea, what decisions would they have made? And those problems, I think, are there regardless. There's going to be a counterfactual analysis that's hard to do. The other thing, though, I think, is that the Supreme Court has collapsed rule and remedy. They're easy to collapse, and you need to keep them separate. In evidence, we do it all the time. There's a rule about hearsay, and then if it's admitted, then you say, well, was it harmless? And we do those things separately. The Supreme Court at one point says, well, we don't really need to keep them separate. They collapse them. So you're constantly mixing up. Are you looking at it ex post or ex ante? Are we talking about what the rule is or what the remedy ought to be? And you have confusion, just incredible confusion around Brady ever since that. And I think what we need to do is go back and talk about what the rule should be, and separately, what should the remedy be, both in a guilty plea context and in the trial context.
Just one other comment there, and it also points out why, at least in my own view, that the better solution to this problem is rulemaking rather than constitutional law, because you can set up rules that carry with them checks and enforcement mechanisms before the fact. You could, some of the local rules and some of the federal courts attempt to do that. The Southern District of Florida, I think, the District of Massachusetts, some other places have time sequences where discovery has to be completed, and then they'll consider arraignments and guilty pleas. And they're more flexible than the non-waivable rule that came out of the Ninth Circuit. In appropriate cases, for example, where witness protection really is a serious issue, you could get protective orders and you could deal with those problems. But if you really, I think the solution to this problem is divorcing, as Kevin was saying, the finality issue, the remedy issue from the rule itself, and dealing with the rule itself at a time when it matters, which is before the guilty plea, and beefing up the Rule 11 proceedings so there's a more detailed factual inquiry, for example, to create a better record. That would diminish, asking open-ended questions during the guilty plea process would diminish the likelihood that an innocent person would be up there pleading guilty. There's a number of things that could be done. It would slow the process down a little bit, which personally I think would be a good idea.
We should probably pause now for a short break before our next panel. We'll begin again at 11:20. So thank you.